Hey everybody, Billy Obenauer here, continuing our discussions on Noe and colleagues' Fundamentals of Human Resource Management textbook. In this lesson, we're going to be going over Chapter 3, which focuses on providing equal employment opportunity in a safe workplace. Now, when I teach this lesson, I like to encourage students to summarize the chapter in a sentence, and that sentence is do the right thing. And you might wonder why I pick such a simple sentence to summarize a chapter where we're going to talk about legislation, we're going to talk about court cases, we're going to talk about government regulations. Well, the answer is pretty simple. All these things I just mentioned, they are constantly evolving, all right? We are seeing new legislation emerge. We are seeing landmark judicial cases that are changing the way we understand our current legislation, okay? And it can be difficult, it can be challenging for managers and human resource managers to stay up to date on the most current legislation and the most current court cases. It can even be challenging for them to adapt to these changes. But if we're constantly focused on doing the right thing, if we let our moral compasses be our guide, as opposed to simply trying to be compliant with the law, it becomes a lot easier to be compliant with the law and to adapt to changes as they occur. As we consider the role that government plays in regulating human resource management, in the United States of America, there are three different branches of government: the legislative, executive, and judicial branches. Right? And each one of these branches plays an important role in regulating HR. We're going to start with the legislative branch, which at the federal level would be the Senate and the House of Representatives. And they work to create and pass legislation that creates laws. All right, and these laws are essentially what govern our practices in HR. All right, then we have the executive branch, which at the national level would be the president, or the state level would be a governor. And there's two different ways that the executive branch plays an important role in HR. First, the executive branch can pass what we call an executive order, which is sort of like a law, but it's a little easier to overturn because all it takes is a president or governor enacting it. All right. The executive branch also is responsible for agencies that regulate certain aspects of human resource management, such as the EEOC and OSHA, who we'll talk about later on in this lesson. And then finally, we have the judicial branch. And what the judicial branch does is the judicial branch makes decisions about how the law should be applied. All right, so often we have a law that governs something in human resource management, but then we have disagreements over what the law actually means when we look at it in practice in the field. So we may have one party sue another party over what they believe is a violation of the law. Courts will hear the cases, and ultimately courts will have to make decisions about how the law applies to the case. These decisions will then serve as a precedent for how organizations will apply the law in the future. In terms of why the government gets involved in HR, a lot of their efforts have focused on equal employment opportunity, or ensuring that all individuals have an equal chance for employment. All right, and as we mentioned, many of the efforts to create EEO include constitutional amendments and legislation that are passed by Congress or the legislative branch, executive orders that are passed by the executive branch, and court decisions that are enacted by the judicial branch. Next, we're going to look at a few important pieces of legislation. We're going to start with the Equal Pay Act of 1963, which states that males and females need to receive equal pay for equal work. Now, this does not mean that all males and females need to be paid exactly the same. The Equal Pay Act of 1963 allows for differences in compensation based upon factors such as experience, education, night and weekend differential, or paying people more to work overnights or to work on the weekends, and so on and so forth. All right, and these potential justifications make it really complex to identify and understand whether or not organizations are in compliance with the Equal Pay Act. All right, but what we do know is that over half a century after the Equal Pay Act was passed, we still have issues of gender equity in terms of compensation in the United States. So we still have work to do in this area. All right, then we have Title VII of the Civil Rights Act of 1964, and this was a piece of landmark legislation in the United States. It was passed by the 88th Congress and enacted by President Lyndon B. Johnson. And you see over here in the pictures as civil rights leaders looked on as Johnson signed this law into place. All right, we actually see Martin Luther King Jr. over here right behind Johnson. All right, and what this law did is it prohibits discrimination based upon race, color, religion, sex, or national origin. All right, and it's enforced by the Equal Employment Opportunity Commission, which is regulated by the executive branch of government. The Age Discrimination and Employment Act made it illegal to discriminate against an employee or job applicant on the basis of their age if they're 40 years of age or older. All right, the Pregnancy Discrimination Act of 1968 defined pregnancy discrimination as a form of sex discrimination, therefore making it illegal to discriminate against someone because they're pregnant. In other words, if a job applicant comes in for an interview and you can tell that they're pregnant, you can't consider whether or not they're going to go out on maternity leave soon in your hiring decision. All right, the Americans with Disabilities Act of 1990 made it illegal to discriminate against someone on the basis of a disability, and it also clearly defined the word disability so that we didn't have any ambiguity there. All right, so that definition included someone who had a physical or mental condition that limited major life activities. All right, it includes someone who's previously had a condition that limited major life activities. So for example, if you were a cancer survivor and your cancer was in remission, all right, but you no longer actively had cancer, you're still covered under the Americans with Disabilities Act. And what this means is that if you have regular doctor's appointments where you need to go in and get scans or get checkups because you had cancer previously, your employer cannot deny you the right to go ahead and do that. And then the definition also included people who are perceived as having a disability. All right, and then finally, the Civil Rights Act of 1991 added compensatory and punitive damages to the Civil Rights Act. Now, what that means for employers is that violating the Civil Rights Act was now a much more serious thing in terms of potential financial ramifications. Previously, if you had discriminated against someone on the basis of race and maybe not hired them for a job and they sued you, you might be forced to hire them afterwards. Okay? Now, if they sued you for the same thing, you might not only be forced to hire them, but you might be forced to pay fines, you might be forced to pay them punitive damages. So the implications of violating the Civil Rights Act became a lot more serious for employers. Now that we've talked about some important pieces of legislation related to HR, let's talk about what it looks like when the courts have to make decisions about how these laws apply to the real world. The first case we're going to talk about here is the EEOC versus Abercrombie and Fitch stores from 2015. And in this case, the EEOC sued Abercrombie on behalf of a job applicant who was denied a job on the basis of the fact that she wore hijab to her job interview. Okay, now hijab's related to her religion, but Abercrombie said that they did not hire the applicant because wearing her hijab would violate their dress code, which prohibited headwear. Okay, what the Supreme Court of the United States essentially stated was that that dress code had a disproportionate impact on people of certain religions and therefore qualified as religious discrimination. Since this court case has been decided, Abercrombie has updated their dress code to be more inclusive in nature. In Young versus UPS, the Supreme Court heard a case where an employee was denied an accommodation on the basis of pregnancy while working at UPS. The employee had a doctor's note restricting lifting to 20 pounds. UPS had previously accommodated employees similarly on the basis of disability but denied this request. All right, what UPS's standpoint on this was that they had a policy of honoring accommodation requests on the basis of disability, but they had no such policy for accommodating on the basis of pregnancy. All right, the Supreme Court ruled on this. Their ruling was a little bit complex. I'm going to try to simplify it here. What the Supreme Court essentially stated was that employers can have policies that they accommodate differently on the basis of disability than they do on the basis of pregnancy, but only if they can show that there is a business need for accommodating people differently and that accommodating on the basis of pregnancy would create an undue hardship on the business. Okay, in a practical sense, it's very difficult for an employer to show this. So what this case told employers is that if you would honor an accommodation request on the basis of disability, you should honor a similar accommodation request on the basis of pregnancy. Another important Supreme Court case that has impacted human resource management deals with sexual orientation and gender identity. In Bostock versus Clayton County, Georgia, the Supreme Court said that Title VII protects individuals based upon sexual orientation and transgender status because discriminating based upon sexual orientation and transgender status is discrimination based upon an individual's sex. So let's unpack Bostock versus Clayton County, Georgia a little bit further. Okay, I want to make sure you understand why the court said that discrimination based upon sexual orientation is actually discrimination based upon an employee's sex. Okay, so what the court essentially said here is that to discriminate against somebody on the basis of their sexual orientation, first what we need to do is we need to consider the sex of the employee's partner. Okay, and that the sex of the employee's partner is related to a negative employment outcome. But the sex of an employee's partner is only related to a negative employment outcome on the basis of the employee's sex. So essentially what we're looking at is an interaction between the sex of the employee's partner and the employee's sex is impacting the potential for a negative employment outcome. And because sex is a protected class, that's why discriminating against an employee on the basis of their sexual orientation is actually discrimination based upon the employee's sex. Next, we're going to talk about how the executive branch of government plays an important role in regulating human resource management. Now, when we learned about the Americans with Disabilities Act, you may have been wondering, are alcohol and drug abuse covered under the ADA? And the answer to that is yes, they are, but there's some stipulations. All right, and the U.S. Commission on Civil Rights does a nice job of providing some guidelines regarding rights and responsibilities on their website. Okay, and if we were to summarize this, we would say yes, drug and alcohol abuse are covered under the ADA, and employers do need to make reasonable accommodations. So if an employee needs time off to, say, go and check into a rehab facility, or if a person needs a certain time off so that they can routinely go to meetings, these types of things do need to be accommodated. Okay, however, from a legal standpoint, drug and alcohol abuse cannot be used to excuse poor performance on a job, and there is no reason to hold someone to a different performance standard on the basis of drug and alcohol abuse. In terms of equal employment opportunity, government contractors are held to an even higher standard than those in the private sector who do not do business with the government. And the Office of Federal Contract Compliance Programs within the U.S. Department of Labor regulates the performance of government contractors within the realm of equal employment opportunity. They enforce executive orders that cover companies doing business with the federal government. They audit government contractors to ensure that they're actively pursuing the goals in their affirmative action plans. And they also make sure that plans utilize analysis, goals, timetables, and action steps. And then previously we've mentioned the Equal Employment Opportunity Commission, better known as the EEOC, and the EEOC is responsible for enforcing most of the EEO laws that we've talked about. The EEOC investigates and resolves discrimination complaints. They monitor organizations' hiring practices by collecting and analyzing the EEO-1 reports. The EEO-1 report is a report that organizations fill out that talks about diversity in hiring. Okay, it is not a publicly available report. All right, this is private information collected by the EEOC. The EEOC also issues guidelines to determine law violations, and one of the most popular guidelines, one of the most well-known guidelines that they've issued are the Uniform Guidelines on Employee Selection Procedures, which help to provide organizations with a little bit of a handbook in terms of how they can enact equal employment opportunity within their hiring processes. Now, we talked a little bit about the EEOC's role in investigating and resolving discrimination complaints. And when we look at the types of complaints that are received by the EEOC, the number one complaint they receive is one of retaliation. And this one really bothers me. I mean, all discrimination bothers me, don't get me wrong. But for retaliation to exist, what has to happen is someone has to have the perception that they were discriminated against on the basis of their membership in a protected class. And then after they perceive this, they turn around and they go to the organization and they talk to them. Okay, they say, hey, either I'm not being compensated fairly, or I'm not being provided with leadership opportunities, or I'm not getting something because of who I am in terms of being a member of a protected class. And then the response is that rather than addressing that issue after the employee asks the organization for help, rather than addressing the issue, the organization turns around and punishes the employee, maybe with a worse schedule, maybe with a bad raise, maybe with a bad review. And then only at that time does the employee actually go to the EEOC and say, hey, I need help. Right? If you think about this from the perspective of a manager or a human resource manager, if you have an employee come to you and tell you, I feel I've been discriminated against, it is your responsibility to ensure that you address that issue. This category here of retaliation, it shouldn't even exist, because HR managers should do a better job of making sure this never happens. But unfortunately, it is the most common type of discrimination complaint that is filed with the EEOC. And while the government plays an important role in regulating human resource management in terms of equal employment opportunity, employers need to take ownership of this. And one way that employers can take ownership of equal employment opportunity is by establishing and enforcing an EEO policy. Okay, an EEO policy essentially defines and prohibits unlawful behaviors, so it kind of simplifies the law so that employees and managers understand what it is that they need to do, and it also provides procedures for making and investigating complaints. An important thing to note about an EEO policy is that it can be more specific than the law. Okay, so where the law can sometimes have some ambiguities to it, where people may not specifically know, what constitutes discrimination, what constitutes harassment, and so on and so forth. An EEO policy can list specific things. It can prohibit specific behaviors. Employers also have a responsibility to provide employees with a reasonable accommodation when necessary. And what that means is that you have to do something to help otherwise qualified individuals perform their jobs. And some of the categories that we'll consider reasonable accommodations on the basis of are religion, pregnancy, and disability. All right. Now, some employers may think that they're going to be exempt from an accommodation. This may be the case if an accommodation would require significant expense or difficulty, which is what we call an undue hardship. All right, an example of an undue hardship might be if you ran a business that did $500,000 a year in sales and an employee asked for an accommodation that required you to purchase a technology that cost over $5 million. That might be considered an undue hardship because your investment would be more than 10 times your annual revenue. All right, but the truth of the matter is that employers often perceive more hardship than what actually exists. So it's very important that as we consider accommodations that we try to look at this through an unbiased lens. So what do reasonable accommodations look like? Reasonable accommodations can include factors such as making facilities accessible, modifying work schedules, and acquiring or modifying equipment. Okay, but it's important to remember that reasonable accommodations do not include hiring unqualified people, lowering your quality standards, or compromising worker safety. Now, we've talked a little bit about the Americans with Disabilities Act and the types of reasonable accommodations that may be requested under the ADA. Now, if we don't honor these accommodations requests, we do run the risk of having complaints filed under the ADA. And some of the different disabilities that have been associated with complaints filed under the ADA in the past are hearing disabilities, cancer, diabetes, back injuries, but the most common disability associated with complaints filed under the ADA are emotional and psychiatric disabilities. These account for over 26% of the complaints filed under the ADA. One of the most common accommodations requested for employees with emotional and psychiatric disabilities is a flexible work schedule. Now, I've got something I want you to think about here. When the COVID-19 pandemic hit our world, organizations all over the globe figured out how to be flexible in terms of workplace practices so they could keep their businesses running. If we have employees who need some flexibility in employment to ensure that they're going to be okay, we know that we can figure out how to do it. We were just forced to by the pandemic. Okay, so we know we can. we need to make this happen for our people. As we move forward here, we're going to cover a few key terms to make sure you're familiar with them. The first of these terms being disparate treatment. And what disparate treatment means is to treat people differently on the basis of their race, color, religion, sex, national origin, age, or disability status. Okay, in order to avoid disparate treatment, companies should evaluate interview questions and make sure the decision criteria are based on job-related factors. Okay, so we wouldn't want to have interview questions that are related to things that only young people are going to know, because then we're going to be discriminating on the basis of age. All right, related to this, we need to understand what our bona fide occupational qualifications are. Okay, and these are necessary qualifications for performing a job. All right, so let's say we have a lifting restriction in a job. Okay, maybe we say employees need to be able to lift 50 pounds to work in this position. Okay, that's a bona fide occupational qualification only if employees have to lift something that's 50 pounds. If the heaviest thing someone's ever going to have to lift is 25 pounds, then having to lift 50 pounds is not actually a bona fide occupational qualification. One type of disparate treatment that you may be familiar with is called sexual harassment. And this refers to unwelcome advances, requests for sexual favors, and other verbal or physical contact when submission to the conduct is a condition of employment, submission or rejection is a basis for employment decisions, or the conduct interferes with the employee's work performance. And as we consider these 3 bullet points, all right, that really gives us 2 different types of sexual harassment. The first one is called quid pro quo, and this basically is an exchange. What it means is if you submit to a certain behavior, you will receive some type of desired outcome. And the first 2 bullet points here really fall under that quid pro quo category. All right, and then we have what we call a hostile work environment. And the hostile work environment is really that situation where conduct interferes with the employee's work performance. And there are a variety of different types of factors that can contribute to a hostile work environment. All right, so maybe we have inappropriate pictures up on the wall in the workplace, or people are telling sexual jokes, or someone is touching or invading personal space. All right, the important thing to remember here is it doesn't matter if the person who is doing these things thinks that they're engaging in sexual harassment. What matters is if you're making someone else uncomfortable and that conduct is interfering with their work performance. Okay, so if every time a person sees you, they get stressed out because they're worried that you're going to invade their space or touch them in a way that makes them feel sexually uncomfortable, and that's preventing them from performing their job in some way, shape, or form, that's sexual harassment because you're creating a hostile work environment. As managers and human resource managers, there's a few things that we can do to prevent sexual harassment in the workplace. All right, we could start by developing and communicating policies that define and forbid sexual harassment. All right, we can work to train our employees to recognize and avoid this behavior. This means talking through examples, helping them understand exactly what sexual harassment is. All right, we can also provide a means for employees to complain about harassment, and they need to be protected from retaliation. Not only do we have to have a plan to protect them from retaliation, but we need to make sure that they're comfortable, that they understand that that plan is going to work. Because if they don't think our plan is going to work, they're not going to be comfortable reporting something. All right, we need to make sure that we understand we can't accept responses like it's just a joke. Okay, these types of things have no place in the workplace. All right, it's just a joke is not acceptable if it's sexual harassment. Another type of discrimination that we're going to talk about here is called disparate impact. And disparate impact differs a little bit from disparate treatment because while disparate treatment is discrimination on the basis of one's demographic characteristics, disparate impact is a condition in which employment practices seem neutral but disproportionately exclude a protected group from employment opportunities. And this is often not intended by the employer. All right, the Abercrombie case is a great example of this. Abercrombie had a policy that employees couldn't wear anything on their head, and it seemed like a neutral policy, but it disproportionately excluded people on the basis of their religion. All right, so how do we identify disparate impact? Well, obviously we can understand the impact of different rules, but if we're looking at this from a big picture standpoint, sometimes we can use something called the 4/5 rule to help us out. Okay, and this is used to test disparate impact in hiring practices. And basically what we do is we look at the hiring rate for a minority group, and we look at the hiring rate for a majority group. And if the hiring rate for the minority group is less than 4/5 the hiring rate of the majority group, then there's some evidence of potential discrimination. Now, the easiest way to understand the 4/5 rule is to look at it through the lens of a mathematical example. So we're going to do just that here. In this example, a new hotel has to hire to fill 100 positions. Of the 300 total applicants, there are 200 black applicants and 100 white applicants. The hotel hires 40 of the black applicants and 60 of the white applicants. So now let's take a look and see if the conditions of the 4/5 rule are met. So we're going to start by finding the rates, and we see of the 200 black applicants, 40 of them were hired, all right, and that's 20%. Of the 100 white applicants, 60 of them were hired, and that's 60%. So we're going to set the rate for the minority as our numerator, that's 20%. We're going to set the rate for the majority as our denominator, that's 60%. And what we can see is that the ratio here is 0.33, and that's less than 0.8. or less than 4/5. So here the conditions of the 4/5 rule were not satisfied, and that provides some evidence that there was potential discrimination here. Now what we have to remember is that the 4/5 rule is not absolute. Okay, so if this ratio here is under 4/5, it doesn't mean that there definitely was discrimination, but it does mean that there's a pretty strong possibility that there was, and it's definitely worth us investigating it. Now, as we think about how to apply the 4/5 rule in practice, it can be rather complex, and that's illustrated really well by the case Ricci versus DeStefano. This case deals with the city of New Haven, Connecticut, who had a firefighter's promotion exam, and when they got the results back, what they found were that a much higher proportion of white firefighters who took the exam passed it than minority firefighters who took the exam. So I'm going to focus here on the data for the lieutenant exam. All right, we'll take a look at that right here, and what we see are that 43 white firefighters took the exam, 25 of them passed the exam, and that gave us a proportion passed of 58%. All right, then we have 19 black firefighters took the exam, 6 passed the exam, that gave us a proportion pass of 31%, and then 15 Hispanic firefighters took the exam and 3 passed for a proportion passed of 20%. Now, when we compare the proportions passed, when we compare the proportion of black firefighters passed to the proportion of white firefighters passed, what we see is we have a ratio here of 0.54. When we do that for Hispanic firefighters, we have a ratio of 0.34. Both of these ratios fail to meet the 0.8 threshold or 4/5 threshold by a considerable amount. If we move even further over and we look at the proportion eligible for promotion, and this is just the number of people who are eligible for promotion immediately, okay, other people who pass the exam would become eligible for promotion later on. What we see is that all the people who are eligible for promotion were white. Okay, so 23.26% of the white firefighters who took the exam were immediately eligible for promotion, and then 0% of the black or Hispanic firefighters were immediately eligible for promotion to lieutenant. All right, so the city of New Haven saw this data. They saw that there seemed to be evidence of discrimination here, and they decided to throw out the exam results. Okay, this case ended up going up to the Supreme Court. And what the courts ruled was that it was illegal for the city to throw out these results. All right, the city had said that they were concerned about being accused of discrimination, about being sued for discrimination. The court said that is not a sufficient reason to throw out the exams. Okay, so this shows us that we can have a little bit of a problem here when we try to look at our employment practices and we recognize something and we try to figure out what to do with it. So what do we do if we're the employer here? Well, the problem is by the time we've gotten through the selection process and recognize that there's an issue, it's a little bit too late for us to be acting. All right, in this case, the city really needed to be testing the validity and reliability of their exams before administering the exam. They needed to be examining questions for racial bias before administering the exam. If we get to this point that we've gone through our entire selection process and then we start to discover that there's some evidence of discrimination, we've gone a little bit too far and we're not always going to be left with a lot of good choices. Now that we've talked about equal employment opportunity, we're going to talk about providing our employees with a safe workplace. All right. And in 1970, the United States government passed the Occupational Safety and Health Act. And this was passed in response to over 15,000 work-related fatalities that had been occurring every year. And what the OSHA Act did was it authorized the government to establish and enforce occupational safety and health standards. And to do this, they created OSHA, the Occupational Safety and Health Administration. And OSHA inspects employers for safety and health standards and levies fines for violations of these standards. Within the OSHA Act, there's a general duty clause, and the general duty clause basically says that employers need to provide a safe workplace for their employees. Okay, that workplace needs to be free from hazards that cause or are likely to cause serious death or injury or physical harm. Okay, now obviously what a safe workplace looks like is a little bit different based upon the industry that you're in, right? So we might expect a college campus to be a little bit safer than working in a rail yard or something of that nature. But generally speaking, even if a workplace is considered to have some unsafe nature to it, employees still should have minimal risk of death or serious injury. Okay, and employers are also required to keep records of work-related injuries and illnesses and post an annual summary of them where their employees can see them. Employees have a variety of rights under the OSHA Act. These rights include requesting an inspection from OSHA concerning safety issues in the workplace, having a representative present at the inspection, having dangerous substances identified, and often this is done through material data safety sheets, being promptly informed about exposure to hazards and given access to accurate records regarding their exposure to these hazards, and having employer violations posted at the worksite for them to review. While employees have rights under the OSHA Act, they also have responsibilities. So yes, employees can file complaints and request inspections. Yes, employees do have a right to know about hazardous materials and to receive material data safety sheets that tell them about the hazards of materials and products that they're working with. They have all these rights, but they also have to follow OSHA safety rules governing employee behavior. Employees cannot behave in an unsafe manner in the workplace. They also have to report hazardous conditions in the workplace. Employees can't consciously decide to work in an unsafe workplace without reporting it to OSHA. All right, these responsibilities are a key to employees utilizing their rights under the OSHA Act. Employers are also required to fill out a summary of work-related injuries and illnesses, and this will include information around the number of cases in the organization, the number of days lost or the number of days that employees are transferred, and the types of injuries and illnesses in the workplace. And employees have a right to inspect these forms. Now, OSHA also has responsibilities. OSHA is responsible for inspecting businesses, and OSHA regulations prevent OSHA from actually notifying employers ahead of inspections. So employers cannot have any notification. Inspections need to be surprise inspections so that OSHA is getting a realistic perspective of what the workplace looks like. All right, OSHA is also responsible for applying safety and health standards in the workplace and for fining employers who are not compliant with safety and health policies. Okay, OSHA also puts together literature that informs employees and employers of their rights and responsibilities under the OSHA Act. So what does an OSHA inspection look like? Well, it's going to start with the OSHA inspector conducting a review of the company's safety and health records. Then the inspector is going to tour the premises, all right? And this is going to be a tour that is determined by the inspector. The employer is not going to be able to tell the inspector where they can and cannot go. The inspector is going to determine where they need to go. They're going to evaluate the workplace for safety and health violations and different hazards and things of that nature. All right. The officer is also going to conduct interviews with employees. Okay, so they're going to hear what the employees have to say about safety and health practices in the workplace. And then finally, the OSHA inspector is going to conduct a closing conference with the employer. And at this point, they're going to disclose any violations that they've found. The employer is then going to be responsible for correcting these violations within the time period that's designated by the OSHA officer. Now you may be wondering how effective the OSHA Act has actually been. Well, it's certainly raised the level of awareness of occupational safety in the workplace. All right. We can also see from the graph below that the combined rate of illnesses and injuries in the workplace has steadily been decreasing. All right. Unfortunately, however, we've seen an increase in the number of claims of retaliation against employees who report injuries. This doesn't necessarily mean, however, that employers are retaliating more. All right, OSHA has worked very hard to make workers more aware of their rights, and they've also created a system where workers can file complaints online. So the increased number of retaliation claims that we're seeing could be related to increased accessibility to filing claims, but we can't really be sure about that. Employers are going to be most successful at maintaining a safe workplace when they have their own safety and health programs in place beyond what is required by OSHA. And as we look to identify and communicate job hazards, we may engage in something called the job hazard analysis technique. And this is a technique where we essentially break down jobs into basic elements or basic tasks, and then we rate each one on its potential for harm or injury. Okay, and then we look at the tasks that have the greatest risk of harm, and we try to address the risks associated with those tasks. Now, one of the challenges with the job hazard analysis technique is that we may have some bias in terms of how we evaluate different tasks. Okay, so if we've performed a task ourselves, we may not see it as dangerous as we would if we hadn't performed it. Okay, we may not be aware of certain hazards. So we may not be aware of what people might be breathing in on a shop floor. We may not evaluate a task on the shop floor as accurately as we should because we're not aware of that risk. Okay, another tool that we might use is called the technique of operations review, and what we do here is we essentially look at past accidents and we try to connect them to elements of jobs that caused the accidents. Then we try to address the safety issues within those jobs that were related to the accidents. Okay, it's important to remember that as we work through health and safety programs, we really need to communicate job hazards and risks to our employees effectively. Okay, and this means our communication has to fit our audience. I've done a lot of work in terms of safety research and looking at warnings and messages and how people respond to them. And there's a lot of variation in how people respond to different messages. So we really need to engage in researching these areas, understanding how our employees are going to respond to different messages, and engaging in messages properly. We also want to engage in practices that reinforce safe workplace behaviors. Okay, so we're going to set goals for our employees. Maybe we set a goal that we want to go a week without having a workplace accident. Okay, and then we're going to have incentives to reinforce these goals. So maybe if we go that week, we have a pizza party. Maybe if we go a year, everybody gets a bonus. All right, you're going to work out an incentive system that's going to motivate your employees to engage in safe workplace behaviors. And you want to recognize that it's important to target the jobs that are most likely to cause injury, the jobs that have the greatest risk associated with them. All right, so it's a lot more important to have these incentive programs lined up for people who are working on the floor of a factory and operating heavy equipment than it is for somebody who's sitting at a desk in an office. Finally, we need to recognize the importance of promoting safety internationally. Our international employees have the same right to a safe workplace that our domestic employees do. Okay, but sometimes cultural differences can make it a little bit challenging to promote safety internationally. For example, in a country that has a high power distance culture, employees may be less comfortable reporting a safety issue than in a country that has a low power distance culture. All right. We also need to recognize that a training that is appropriate in one country may not be appropriate in another country. But despite any challenges that we may experience promoting safety internationally, we need to recognize that as managers, it is our responsibility to ensure a safe workplace for all of our employees across the globe. Thanks for joining me here for this lesson on equal employment opportunity and a safe workplace. This is Billy Obenauer saying, hope you enjoyed it, hope you learned something, and we'll talk to you soon.